Hello friends, in the series on the income tax cases, today we will discuss the case of Mallikarjuna Rice Industries versus Income Tax Officer. This case has been reported in 458 ITR at page number 566 and the matter has been decided by Telangana High Court and the date of the judgment is 15th February 2023. This case is related to the assessment year 98-99 and the litigation on this case ended in February 2023. So near about 23 years it took to give the relief to the assessee and to put an end to the litigation only just because that the department is not able to fulfill its duties well. And the Income Tax Act gives enormous power to the income tax officers that if they have not done an assessment order in a sensible manner, then they have wide powers under various sections that they can issue the notice to the assessee and try to cover up their mistakes. This is the perfect case to understand this point. In the present case, the assessment of the assessee was done under section 143 subsection 3 and during the assessment proceedings an issue got settled regarding research and development cess liability, which after the various submissions from the assessee it was settled and no addition was made by the assessing officer in this regard. When the assessment was over, the assessing officer felt that he has made some mistake and it should not be allowed. So the assessing officer issued notice under section 154 regarding the same issue, that is research and development cess liability. The assessee again submitted various replies, submissions, and once again the assessing officer was satisfied with the submissions of the assessee and settled the issue without making any addition on this issue. After some time, again the assessing officer felt that the research and development cess addition should be made in the hands of the assessee and he recorded the reasons and issued the notice to the assessee. Now, it was a case for the assessee in which it can be said that the assessee has to explain its point each and every time when the notice comes on the same issue. So the assessee was a little bit irritated also and he went to the High Court by filing the writ petition. It was the viewpoint of the assessee that change of opinion is not allowed under section 147 read with section 148 when the same issue has been raised two times earlier. First under section 143 subsection 3 an opinion was made by the department that no addition should be done. Again, the opinion was settled in favor of the assessee under the proceedings under section 154. So, if the same issue will be allowed to raise again and again, then it is a classic case of change of opinion, which is in no case allowed under section 147 read with 148. And the Telangana High Court quashed the notice. Friends, the issue here is that whether and why assessee should be penalized for this when the assessing authorities are not able to take some decision and they are just passing the orders without going into the merit of the case. Then whether these sections, whether section 147, 148 or the section 263 revision proceedings are there when they are just initiated by saying that the order passed by the assessing officer is erroneous. So if anything happens and the department goes for re-opinion or when the department goes for issuing the notice under section 148 when the assessment has been completed under section 143 subsection 3 or when the commissioner goes for initiation of revision proceedings under section 263 against the order passed by the assessing officer saying that the order is erroneous. So there should be some law that when the assessing officer has not done his duty in a sensible manner, there should be some cost on the assessing officer. If the department itself is saying that your order is erroneous and something has been left by the assessing officer, then why the assessee should suffer? This is the main question. But our law is like that. In the end, after 23 years, because the assessment year was 98-99 and the issue got settled in 2023. At the end of this video, once again, I am repeating the name of the case. The name of the case is Mallikarjuna, Rice Industries versus Income Tax Officer, and this case has been reported in 458 ITR at page number 566, and the matter has been decided by Telangana High Court, and the date of the judgment is 15th February 2023. Thank you, friends.